Hello learner, welcome to our continuing classes. In our lesson today, we are continuing with our human resource management subject. And in the human resource management subject, we are looking at the lesson on separation strategy. And in today's lesson, we are going to concentrate on looking at the legal provisions on employee separation. It is important to note that an employment contract that an employer and an employee engage in is a contract of service that is admissible in a court of law under the Employment Act, specifically for employment contracts in Kenya and other countries as the case might be. So that's why it's very important as a human resource practitioner, as a human resource student, as an employee, as a supervisor and a manager, to be aware of the provisions that we need to be sensitive to when it comes to terminating the employment contract. So when it comes to the legal provisions on employee separation, the employer has to ensure that the law is followed in termination of employment. Otherwise, that kind of a termination may be termed as an illegal. It may be termed as an illegal termination, and it may have far-reaching consequences on the relationship between an employer, an employee, and the state. And hence, that's what we are saying, that the employer has to ensure that the law is followed in termination of employment. Otherwise, the termination may be termed as illegal. An appropriate notice, and this is very important, an appropriate notice of termination, of employment has to be given by the employee or the employer. So dear learner, in our previous lessons, we have looked at the direction of termination, and an employee can be able to initiate a termination. An employer can also be able to initiate a termination, but what is critical that a notice of termination of employment has to be given, whether it is by the employee or by the employer. And in Kenya, according to the Employment Act, which is the principal act that governs the employee-employer relationship, Section 45 and 46, Section 45 and 46, an employer can be allowed to terminate the services of an employee due to various reasons that may be advanced in law or within the contract that has been entered into. So we want to have a look at reasons for termination of employment, reasons for termination of employment. We want to look at some of those reasons, reasons for termination of employment. Now, dear learner, it is important that when it comes to terminating an employment contract, especially the employer, has to be very sensitive, because this is a process that can be challenged in a court of law, and usually the law may require that the human resource file or personnel file for this employee is produced in a court of law. So one of the reasons that is identified under the Employment Act, Section 45(2) and 46, the employer can be able to terminate the services of an employee. One, poor performance. Poor performance. So what is meant by this is that when an employee is hired initially in a given organization, this employee agrees that the employee agrees that I as an employee will be able to perform the duties of my position in the following arrangement. So if this employee is a driver, for example, then this employee is assigned the duty of a driver and should be able to drive maybe the organizational vehicle or machinery or equipment as the case might be. So if that employee's performance standard has been agreed at the beginning, then that employee has to sustain that level of performance. But if it continues to fall, arrangements are done to sustain it and it doesn't improve, then that could be a reason that the employer can be able to advance to be a cause of terminating a contract of employment. Number two, misconduct. Misconduct. So if an employee is supposed to behave in accordance to maybe a code of conduct, there could be a code of conduct that an employer has. So based on that code of conduct, if an employee is expected to perform in a particular way and that employee does not perform to the expected standard or behave in accordance to that code of conduct or code of ethics, for example, then that misconduct can form a basis of terminating that particular employment contract. Then thirdly, physical incapacity. Physical incapacity. So this means that if you are, for example, you have employed a supervisor. Let us take an example. You have employed a supervisor, and the work of this supervisor in, let's say, a production setting is the ability to move and supervise work. That employee is expected to move and supervise work within a given working environment. So if this employee, for example, is not able to walk, or this employee is not able to stand for long hours, then that physical incapacity of that particular employee can be the reason that can be advanced by the employer, that this employee has been employed as a supervisor in this particular organization, but that employee does not have the physical strength or the capacity, then that can be a reason why that can be terminated. So there is also the element of participation in an illegal strike. Participation in an illegal strike. Now, though the law provides that employees can be able to participate in a strike, but the employees are expected to participate in a legal strike. So this must be noted very carefully. If an employee participates in a legal strike that has followed the processes, then if the employee services are terminated on that basis, then that termination can be termed as an illegal termination. But where an employee participates in an illegal strike, it means that strike is not sanctioned. Maybe that strike is not backed by a legitimate reason. No notice has been given. Then this kind of an employee, in accordance to the Employment Act, the law gives the employer that particular leeway to be able to terminate the services of this kind of an employee and indicate that this employee has participated in an illegal strike, and that is a ground for termination. Then there is the element of retrenchment. So where, for instance, an employee's services are considered to be surplus to need, or an employer, for example, has faced an economic reason, due to economic reason, the employer is not able to sustain a particular number of employees. So due to that particular reason, the due process can be followed, and that particular employer can be able to cite retrenchment and argue, I have a workforce of 1,000 employees, but at the moment I can only sustain 600 employees, such that 4 workers can now be declared surplus, and those 400 employees can be retrenched. So this could be a reason why an employer can also be able to terminate the services of a given employee or have that particular termination takes place. Then there is also the element of number 6, expiry of a contract of employment. Expiry of a contract of employment. So what happens is this: if an employee has agreed to work for, say, 12 months from January to December of a given year. So when the year begins in January, then the contract begins in January. So if the contract is ending on the last day of September, so that is now the expiry of that particular contract, and an employer can now be able to terminate employment and cite expiry of a contract as the reason for termination. So dear learner, this is what is provided in law. But what is important is that when it comes to the employee or employer, what should be noted here, So if you have an employer who wants to terminate a given contract of employment, or you have an employee, and we have said an employee can also terminate a given contract. For example, we have cited, say, resignation. So if an employee, due to their own volition, decide that they are resigning, then that employee may resign from that particular position. Or the employer, as we have said here, can be able to retrench a given employee. So what is important, learner, is that there is what is referred to as notice period. A notice period. So in the terms and conditions of engagement or employment, the employer and the employee are expected to have agreed. For instance, if the employer is supposed to terminate the services of a given employee, the employer is supposed to have a notice period. And this notice period may, for example, be 1 month. 1 month, for example. So what the employer is supposed to do, if we are in the month of June, and the employer wants to terminate the services of this employee, that employer is expected to provide within the month of June. The month of July is the notice month, so that at the end of the month of July, the services of that employee will be terminated, so that now by the end of July, come the month of August, the employer can terminate that particular contract. So that is what is called the notice period. So the law provides that where the employer may want to terminate the services of that employee other than summary dismissal, then that employer is expected to pay 1 month notice, 1 month notice, in lieu, 1 month's pay, 1 month's pay, supposed to be 1 month's pay in lieu of notice. 1 month's pay in lieu of notice. So supposing this particular employer is in the month of June and would want to terminate the services of that employee in the month of June. So if that employee earns 50,000 shillings per month, so what the employer is expected to do within the month of June, then the employer should pay 50,000 shillings for the salary for June and pay 50,000 shillings for the month of, for the notice, that is the in lieu of notice. Then this amount of 100,000 shillings is forwarded to the account of that particular employee, and the employee is informed within the month of June that this is the payment in lieu of notice. So in the month of June, instead of getting 50,000, you will get 100,000 shillings, and come the month of July, that employee will not be working. So this is what is supposed to be followed in relation to termination of employment as a result of not providing the notice. If the employee also would want to terminate the services, then the employee is expected to do the same. Give a 1 month notice or compensate the employer 1 month equivalent of notice to be able to terminate that particular contract. So dear learner, this is very critical when it comes to legal provisions in relation to employee separation. And we want to go through this again. It's a very critical area because if it is not done very well, it may lead to legal disputes. So we want to look at what is meant by the legal provisions on employee separation. And we have said, dear learner, that the employer has to ensure that the law is followed. And the law we are talking about here is the Employment Act 2007, which is the principal law that deals with the aspect of employment. So in Kenyan scenario, the employer has to ensure that the law is followed, and specifically section 45, subsection 2, and section 46. And an appropriate notice is expected to be provided in terms of the employment, so that that employee is given a notice. And even if it's the employee, for example, terminating, then that employee should also be able to give the employer the necessary notice. So the reasons that we have looked at that an employer can be able to provide for termination of employment in accordance with the Employment Act are the following. So number one, poor performance. So this is where an employee is not performing consistently to the standard that was expected in relation to that employment contract from when the employee was hired from the beginning. So number one, poor performance can be a reason for termination of employment. Then number two, misconduct. So when it comes to the code of conduct in a given organization, so where an employee does not perform in accordance to the code of conduct, then that particular employee's contract can be terminated. Then number three, physical incapacity. So where an employee is not able to sustain and continue working physically in a given organizational setting, then physical incapacity can be a reason for termination of employment. Then number four, participation in an illegal strike. So where an employee is construed to have participated in an illegal strike, this could be a ground for termination of employment. Then number five, retrenchment. So where the services of a given employee may be considered to be surplus, then that can also be considered to be a ground for termination. Then number six, expiry of contract of employment. So when the contract of employment comes to an end, that particular contract or that employment can be terminated, and the ground for that is the expiry of that particular contract by performance. So dear learner, this has been our lesson for today, which was legal provisions on employee separation under the separation strategy topic of the human resource management paper. And before we terminate our lesson today, I would want to give you an assignment that you need to work on. Your assignment. So your assignment is discuss the reasons under which an employer may terminate a contract of employment, with an employee. So dear learner, this is your assignment. Discuss the reasons under which an employer may terminate a contract of employment with an employee. So that is your assignment, dear learner, and we have come to the end of our lesson today. So thank you very much for being active in our lesson.